Good afternoon. Welcome to Landmark Chambers' fourth environmental update webinar, Current Issues in Environmental Law. We've been focusing over the last series of seminars, particularly on the provisions of the Environment Bill, which is currently stalled in Parliament like a lot of other legislation, but is due to come back before Public Bill Committee towards the end of the month if the postponed timetable is adhered to. We're focusing today on a major issue under the bill, which is the bill's handling of biodiversity and nature conservation, which has significant consequences, not merely in environmental law, but in planning as well, particularly the requirements for biodiversity, net gain and conservation covenants. We're delighted to see so many of you joining us today, and we hope you find the presentations and the discussion to be useful. I'm David Elvin, QC, and I'll be chairing and will be joined by my colleagues Matthew Fraser, Stephen Whale and Richard Turney, though I'm afraid that Matthew has been having IT problems, and although his presentation goes first, what I'm proposing to do is to deal with the general policy issues and the introduction to the bill for him, and then pursue Stephen's paper straight away after that, and then Matthew can come back and deal with the matters of substance he was going to deal with when he's managed to get online. Can I just give you a few housekeeping points? Please note that your microphones are automatically muted, so you won't need to make any adjustments yourselves. We welcome very much questions through the session, and you'll see on Zoom the Q&A tab. Please send us any questions that you have, and what we'll do is deal with these at the end. If there are too many questions or questions that require further consideration, we'll follow those up if necessary by email to all attendees afterwards. If you lose your connection at any stage, slightly ironic bearing in mind Matthew's difficulties, but if you lose your connection, just leave Zoom, click on the link again and come back in, and that should work. We are recording the presentation and the slides and the video will be made available, and you'll be notified in due course when that is the case, and it should be available on YouTube. So taking Matthew's role briefly to introduce the bill because of his IT difficulties at the moment, I will introduce the policy side of the bill. So it's not me, of course. It's clear from the bill, along with the general aim of strengthening UK environmental law post-Brexit, that there are significant provisions in both Part 6 and Part 7 dealing with nature, biodiversity, nature conservation. And you see there we have not only biodiversity gain in planning, but biodiversity objective in reporting, local nature recovery strategies, tree felling and planting requirements, and the significant issue of conservation covenants. Stephen Whale is going to be dealing with Part 7 and the conservation covenant shortly, and Richard Turney will be dealing with the other major issue of biodiversity gain, and hopefully Matthew can come back on the details relating to the other matters. The explanatory notes to the bill note that nature is in decline, much of England's wildlife is deteriorating, many ecosystems are degraded. And there is a significant part of the bill's objectives to reverse that. You see under the current section 40, the duty, not perhaps as strong as it might be, requiring public authorities in exercising their functions to have regard, so far as is consistent with the proper exercise of their functions, to the purpose of conserving biodiversity. And that is then defined. This is something which Matthew will be taking you to in due course, which is amended and strengthened by the provisions of the bill. As I've said, the duty is not a particularly strong one. It's a have regard duty. See the Howell case, where the matter is referred to by Mr. Justice Cranston, at least in the matter of listed buildings, showing that the have regard to duty is really just that. It's to take it into account and to bear it in mind with your decision making. It doesn't require you to comply with any particular outcome. and special regard is simply a requirement that gives it particular importance and weight. The proposed biodiversity objective in the explanatory notes is in order to meet the strength of the 25-year environment plan. It shifts the duty away from that weak have regard duty to active requirements to seek further conservation and enhancement of nature, and put greater emphasis on action on biodiversity. This is where I turn then to Stephen, and we'll leave this to Matthew, hopefully, when he's managed to get a connection. If not, I'll deal with it myself at the end. But we'll now move over to Stephen Wales' paper, which is dealing with Part 7 and conservation covenants. Thank you. I think Matthew's now managed to connect, and if that's the case, Matthew, can I ask you to take over from this point onwards?
Yes, so this is the position which is currently proposed in the bill. The idea is to try and, as David's already said, to try and get things a bit more developed in terms of the duty, make it more of a positive, active duty rather than simply having to have regard to the importance of conserving and enhancing biodiversity. So firstly, it's a general duty to conserve and enhance biodiversity. And the general biodiversity objective is defined as the conservation and enhancement of biodiversity in England through the exercise of functions in relation to England. And it's really a three-stage process. The first stage is that a public authority needs to consider what action they could properly take to further the general biodiversity objective. That is something which they need to do from time to time, the first time being 1 year from when the Environment Act comes into force, and then every 5 years. So after you've considered as an authority what needs to be done to promote the biodiversity objective, the two next stages are determining what policies and specific objectives are appropriate for taking action to further that objective. And then the third and final stage is to take such action as is appropriate in light of those policies and objectives in order to further the objective. So it's, as I said, it's a three-stage process. You start by, as an authority, considering what you should do. Secondly, you determine what to do. And then thirdly, you take action according to whatever that determination is. And the determination needs to follow on as soon as practicable from the consideration. Next slide. There are specific provisions which say what action may be taken. They're non-exhaustive, but there's certainly a specific focus on, firstly, conserving and restoring or otherwise enhancing a population of a particular species, and secondly, conserving, restoring or otherwise enhancing a particular type of habitat. And then importantly, in complying with any new duties, the authority must in particular have regard to any relevant local nature recovery strategy. Now, we'll get onto those in a minute and what they are and what they require. But just before we do so, if I could ask for the next slide, please. The corollary to the new general biodiversity objective is the reporting requirement on local authorities to summarize the actions that they've taken already to comply with the new duties, and also set out what proposed future actions they're going to take. And the reporting duty goes hand in hand with the actual actions that are being taken. They have to cover a particular period. Regulations may require reports to include a particular quantitative data, depending on what the Secretary of State decides should be done in that regard. And so that then moves on to if I could ask for the next slide, please. So the local nature recovery strategies, these are the things which are referred to in the general biodiversity objective provisions. What are they? Well, the way in which they're explained in the explanatory notes is that there's already a process going on in a number of local areas where local bodies are getting together and coming up with their own plans for promoting biodiversity. And what the explanatory notes is that the concept of a local nature recovery strategy is putting spatial planning for nature on a statutory footing. So it's effectively codifying what a lot of authorities are already doing, but making it a statutory requirement. Next slide, please. So what are these? Well, they're basically strategies that apply to a particular area. It's up to the Secretary of State to determine the areas to which the strategy should relate, but it's a particular area of a local authority can't be split between two strategies, although you can have a strategy that applies to more than one area. And as I said, compliance with the biodiversity objective requires regard to be had to whatever's in an existing strategy for the area, and they are to be prepared by local authorities, mayors of London, or combined authorities, national park authorities, and so on. They have to be kept under periodic review, and it will be the subject of regulations to determine what the timing of that review will be. Next slide, please. In terms of content, what do they need to include? There are two aspects to the strategy. Firstly, there's the statement of biodiversity priorities, and that will have a description of the area and its biodiversity. Secondly, a description of any opportunities there might be in the area for enhancing or recovering biodiversity. And thirdly, what are the priorities? What are the priorities for biodiversity recovery and enhancement? The second aspect of the strategy is what's known as a local habitat map, which will set out where all the various national conservation sites are, nature reserves, and then interestingly, not just areas that are of particular importance for biodiversity, but areas that could become of particular importance for biodiversity. So there's an aspirational aspect to local nature recovery strategies, the idea of bringing areas that aren't at the moment of particular importance, but may well become so in the future. And also areas where biodiversity recovery and enhancement could make a particular contribution to other environmental benefits. Next slide, please. And then finally, in relation to the subject matter of my talk, the Secretary of State has various duties in terms of assisting local authorities with preparing their strategies. The Secretary of State has to prepare and publish a national habitat map, which will identify national conservation sites across the country and other areas that, in the opinion of the Secretary of State, are of particular importance for biodiversity. The Secretary of State further has a duty to inform responsible authorities of any area of areas which could become of greater importance for diversity if certain actions were to be taken, or where recovery enhancement could make a contribution to other benefits, or, and this is where the Secretary of State's more holistic approach comes in, the Secretary of State has to keep an eye on how these various areas could integrate in order to become a national network of areas for recovery and enhancement of biodiversity. So thank you very much. That's all that I wanted to cover in my talk. Apologies for the technical problems at the beginning, but I'll now pass over to Stephen Wales.
The next paper is Stephen's paper dealing with part 7 of the bill and conservation area covenants. Over to you, Stephen, please.
Thank you. Good afternoon. Well, good afternoon, everybody. I hope you can all see me, and more importantly still, I hope you can all hear me. As was just mentioned, I'm going to deal with the conservation covenants aspect of the Environment Bill. I suppose from basics, a covenant is some kind of legal promise. So we're here dealing with promises in relation to conservation. And if one were looking for a little further definition of what a conservation covenant is. There we have a description. I'll just give people a chance to read that themselves for a moment. So in the context I'm dealing with, they are agreements, formal legal agreements between landowners and some other party to the agreement. And it's an agreement to either do something on the landowner's land or not do something on the landowner's land for a conservation purpose. And we'll come on to what that means in a little moment. They're not an entirely brand new idea. Here I make reference to two current examples of certain kind of conservation covenant. So there's a specific provision in the National Trust Act, but as you might expect, these kinds of agreements have to involve the National Trust as one of the parties, and moreover, these kinds of agreements under this provision can only be obligations not to do something. So negative obligations rather than positive obligations. And as I mentioned there's a similar provision under the Forestry Act. And land lawyers amongst you may know that one of the issues to date is that whilst promises or obligations not to do something may succeed down the line from one landowner to another, there have been more difficulties in terms of positive obligations or positive promises passing from landowner to successor landowner. And these conservation covenants are an attempt to overcome this kind of difficulty in particular. Just by way of a little recent background to bring us up to the present date, the Law Commission looked into this conservation covenants matter back in 2012. There was some public consultation, and then in the middle of 2014 there was a very weighty report published by the Law Commission which recommended a new statutory scheme of conservation covenants in England and Wales. Just note there both England and Wales, and I'll return to that subject too in a moment. And so far as the Law Commission was concerned, if these conservation covenants were going to be on a statutory footing, they were going to have four elements to them. And you can see there the four elements set out. Again, perhaps just give people a moment to have a glance at those. By the way, at the end of the Law Commission's report, they actually included a draft conservation covenants bill. The report was greeted very enthusiastically by the government. It committed to exploring the subject further as part of the 25-year plan. And indeed, that 25-year plan pledged to take forward the Law Commission's proposals for conservation covenants. So we get to the current Environment Bill, Part 7, introduced in the House of Commons at the very end of January of this year. Part 7 of it is devoted entirely to conservation covenants. So the government decided not to pursue a freestanding conservation covenants bill, but rather it's included a whole raft of provisions in the Environment Bill on this subject. I refer here to various clauses in the Environment Bill. I'm dealing with the bill as it was originally introduced. As David mentioned earlier, it's presently stalled in Parliament, but there has already been some proposed amendments to the original bill and some renumbering of the clauses. But I'm going to just concentrate on the bill as it was originally introduced. And conservation covenants are defined in the original clause 103. And I'd invite people to have a look at the end of Part 7, where there's a very helpful index of defined terms within the part. Now then, let's look at conservation covenants in more detail. What actually are they in law, or in the law as proposed? Well, they are, in simple terms, that part of a conservation covenant agreement which is given statutory effect. So just have in mind the overall overarching agreement between the parties and within it you have the actual conservation covenants. There's an analogy in planning law in that there might be a Section 106 agreement that some of you may be familiar with, within which are the actual obligations. So as proposed, the Conservation Covenant Agreement is going to be an agreement between the landowner and some other party. This other party is called a responsible body. Come back to that in a moment. And these kinds of agreements are going to have certain provisions in them. They have to be of a qualifying kind, they have to have a conservation purpose, and the agreement has to be intended by the parties to be for the public good. The agreements have to be in writing and signed, as you might expect. And also, it has to, when one looks at the agreement, it has to be apparent that the parties are intending to create a conservation covenant. Presumably they'll do this by saying as much in the agreement. Don't have to, but I imagine that's what will happen in practice. And then, who then are these responsible bodies who can also be a party to these agreements? Well, the Secretary of State is one, and then other bodies, local authorities, they can apply to be designated as a responsible body. At the moment, local authority as defined does not include parish councils. Perhaps there's representatives from parish councils watching or listening at the moment. But in any event, even if you're not a local authority as defined, you can apply for designation as a responsible body, basically if you are a public body or a charity and your purposes or functions relate to conservation. You've also got to be, quote unquote, a suitable body. But there's also scope for other bodies to apply to. So I wouldn't want people to think that this is limited to the Secretary of State and local authorities. It extends more widely to cover, for example, public bodies and charities. And obviously there's many, many conservation charities out there. And I know that many of them have expressed interest in being designated as responsible bodies. In terms of the kind of qualifying provisions, the agreements have to require the landowner to do or not do something on the land, or allow the responsible body to do something on the land, or indeed require the responsible body to do something on the land. Now, just pause in there for a moment. You see the reference to land in England. I do not know, I will confess, precisely what has happened to Wales and all of this. I suspect it's a devolution matter. When the Law Commission reported, their draft Conservation Covenants Bill made provision for these covenants to apply on land in England and Wales. At the very end of the current Environment Bill, it says in black and white that Part 7 extends to England and Wales, and yet the Speaker in February signed a certificate, one of those English laws for English vote certificates, saying that the clauses of Part 7 only apply to England. So as I say, I suspect this may be a devolution matter and that the Welsh administration has been left to deal with this itself. For the moment, though, as we can see, qualifying provisions relate to land in England. Then, as mentioned, the agreement has to be for a conservation purpose, and there are three kinds of such purposes specified in the bill. I'll just allow people a moment to glance at A through to C. Perhaps the most striking aspect of this is that conservation for the purposes of Part 7 and these covenants is by no means limited to biodiversity. One can see here references to archaeology, architecture and a whole raft of other purposes. And indeed the explanatory notes to the bill give the example of a conservation covenant agreement to help restore a historic country house. Also note Part C and the reference to conserving the setting of the various categories that follow. Indeed, perhaps strictly speaking, I should say that those explanatory notes refer to conserving not simply a historic country house, but indeed its setting. So one can see that there's a wide range of purposes that the parties might have included in their conservation covenant agreements, going much more broadly than perhaps the initial instinct as to what the word conservation means. Now a few miscellaneous points, and then I'll deal with a few other miscellaneous points that are not on these slides. The covenants will be a local land charge, and one applies to register them as such. Importantly, unless the covenant provides for a shorter period, if the land is held freehold, the covenant endures forever. And I do mean forever, indefinitely. If the land is held, there was a lease for more than 7 years, the covenant lasts or endures for the remainder of the term of the lease. As one might expect, the landowner's obligation is owed to whichever responsible body is the party to the agreement, and as one would also expect, landowner obligations generally bind the landowner and successors in title. By the same token, obligations on the part of the responsible body, and again as one might expect, are owed to the landowner in question or whoever the successor happens to be. All fine and dandy so far, so let us suppose an agreement is entered into in the correct form, obliging, let's say, the landowner to do X on the land for a conservation purpose, but then for whatever reason this doesn't happen. What are the remedies available at law? Well, there they are set out. 4 potential remedies available, so the aggrieved responsible body can apply to court for one of those remedies. Specific performance, that's to say an order compelling the landowner to do what it was supposed to do, or an injunction, damages, or order for a payment of an amount due. And the court has to take into account the public interest when determining remedy. In terms of damages, I would mention that the ordinary law of contract applies when it comes to awarding damages, and the court can also award exemplary damages. So if the landowner is in breach and it's profited from the breach, the court can order repayment effectively of that profit. Again, let us suppose agreements are entered into, all fine and dandy, and then down the line the landowner or successor or the responsible body or successor decides they'd like to tear up the obligations or change them in some way. Well, the bill provides for this to be done by agreement. I've set out there the 3 clauses that cover this in the original bill, but also the upper tribunal has power to do this on the application of one or other of the parties. And I mentioned there at the bottom of this slide, if you have a look at Schedule 16 to the bill, you'll see there a range of additional provisions on upper tribunal applications. And the test that's there set out, it can discharge an obligation or modify it if it considers it reasonable to do so in all the circumstances. And there's a little more detail on that in the schedule. I did mention just a few other miscellaneous points that I'd like to mention. I have looked in vain for any adverse reaction to the proposal for conservation covenants, and I can't find one at all. I can find a great deal of enthusiasm for them from such bodies as Natural England, the Country Landowners Association, the RSPB, the National Trust. But as I say, I can't find anybody who's commented adversely on the proposal for a conservation covenant on a statutory footing. So I dare say that they are very soon going to come to pass when the current break in Parliament is lifted. But one might ask oneself, well, okay, they sound all very nice, but why on earth would a landowner sign up to a draconian obligation binding its successors to do something on its land for a conservation purpose, potentially until the end of time? Well, there are two good reasons I can think of. Firstly, they might get money for doing it. There's obviously a whole range of conservation grants out there that one can apply for. And secondly, it may be part and parcel of discharging the obligation for biodiversity gain, which Richard Turney is going to deal with in a moment, and so I'll say no more about it. Two final points about these conservation covenants. They can include provision for public access to the land. Don't have to, but they can do so. And secondly, the responsible bodies have to provide an annual return to the Secretary of State with respect to their particular conservation covenant agreement. So this is effectively a kind of monitoring provision to make sure that these agreements, once signed, don't just gather dust on a shelf. So as I said, Richard Turney is going to deal with biodiversity gain. I think I'll now hand over to him.
Well, thank you, Stephen. Moving from something which, as Stephen said, has proved less controversial, at least in consultations, we'll move to something now which has proved highly controversial, at least in terms of the mechanics and the important details. Richard, will you please proceed?
Good afternoon, everyone. Yes, biodiversity net gain within the Environment Bill. As David has said, there's been a degree of controversy about these provisions. It's certainly an area where developers are particularly concerned, and various campaign groups are also concerned. I won't try and do a sort of full audit of what has been discussed in the bill context. Many of the submissions are available online. I just want to, in a relatively short presentation, explain where the bill stands now in terms of biodiversity net gain, and to give you a sense of how things might go forward as the bill proceeds towards royal assent. So first of all, just briefly, biodiversity net gain today, it's not a novel concept for those working in the planning system. And we see reference to net gain repeatedly in the current version of the NPPF. And indeed, even in the 2012 version of the NPPF, there was reference to the desirability of achieving biodiversity net gain. But certainly it's a part of national policy. And many people in the online audience here will be aware that local plan policies have often taken this point and run with it, including site-specific allocation policies, which have imposed requirements for biodiversity net gain, and of course some practical controversy. And net gain is regularly advanced as a benefit of a development, especially in the context of greenfield housing, where in my experience, many greenfield sites, it's actually quite possible to achieve biodiversity net gain with relatively simple interventions, and therefore it's advanced as a positive element of the development to outweigh other harm. Use of offsetting. Offsetting is at the heart of the concept of net gain. Of course, offsetting can work within the scheme in the sense of losing some elements of biodiversity interest and replacing them with others. Off-site, through specific receptor and enhancement sites, regularly translocation sites, for instance, may involve an element of biodiversity enhancement as well as being the receptor for, say, a reptile translocation. Habitat banks, an area which is emerging. I'm very grateful to Professor David Hill for providing me with quite a lot of information about the work of the Environment Bank in this, somewhat ahead of where policy and the bill lie, but certainly habitat banks have been used for some time. And the use of offsetting matrices, just worth mentioning because this problem I think will remain. The use of offsetting matrices to show no net loss is controversial in its own right. That controversy was explored in the HS2 Select Committee, for example, where there was a substantial challenge by various nature conservation groups to the claimed no net loss of biodiversity in the HS2 scheme. So coming then to the bill, the references I've included, when you get these slides, you'll be able to see on the hyperlink on the in the title there. This is to the track change version of the bill. The numbering of this part of the bill has changed in the course of the parliamentary process. So I'm referring to the track change version, which is on Parliament website. So sections 92 to 94, or clauses 92 to 94 as they are now, will make provision for biodiversity gain. The mechanism for that change is through the insertion of a new section in the Town and Country Planning Act, together most importantly with a new schedule, Schedule 7A of the Town and Country Planning Act, for biodiversity gain in England. And the general thrust is that all permissions are going to be subject to a condition requiring the submission and approval of a biodiversity gain plan. And I just pause for a moment to comment that this is a fairly robust way of introducing this requirement. It's not merely a policy change or a soft requirement to consider biodiversity gain. It is one of the very few mandatory conditions. It will be one of the very few mandatory conditions in the Town and Country Planning Act. It will apply to all permissions subject to some regulations, which I'm going to come on to. And it is effectively entrenched because there are consequential amendments, for example, to section 73 and to section 96A, which prevent later rewriting of the biodiversity gain condition. So it's a robust provision. What does it all mean? Well, the biodiversity gain objective will be met in relation to development for which planning permission is granted if the biodiversity value attributable to the development exceeds the pre-development biodiversity value of the on-site habitat by at least the relevant percentage. So one of those nice bits of legislative drafting which will soon roll off the tongue at planning inquiries around the country. What is biodiversity value? That is the post-development biodiversity value of the on-site habitat, the biodiversity value in relation to the development of any registered off-site biodiversity gain allocated to the development, and thirdly, the biodiversity value of any biodiversity credits purchased for the development. So there's three elements: what's on-site, what is secured off-site, and biodiversity credits. The relevant percentage is 10%, so you need to be doing 10% better than you started with. There is provision for establishing that the pre-development biodiversity value has not been altered by activities for which planning permission was not required. So, for example, by carrying out of clearance of a site to reduce its biodiversity value, there's provision intended to prevent that. The post-development value is the projected value at the time the development is completed, and value can only be taken into account if it is satisfied that it will, the local planning authority is satisfied that it will be secured for at least 30 years. So we look at a 30-year time frame for delivering this biodiversity net gain. And off-site gains can be counted so long as the enhancement is required under a planning obligation or a conservation covenant, which Stephen's just explained in detail, and the enhancement is recorded in the biodiversity gain site register, which will be another register held by the local authority. Biodiversity credits, I suspect the devil will be in the detail for these, but section 94, clause 94 of the bill makes provision for biodiversity credits. It explains that the Secretary of State can make arrangements for the use of credits to meet the gain objective, and that will include the price to be paid for those credits. And payments received by the Secretary of State or on behalf of the Secretary of State may be used to carry out works, to purchase land, and to administer the arrangements. So this is a banking system for biodiversity gain. The idea being, and again, grateful to the Environment Bank's useful resources on this, the idea being that biodiversity credits may be a more efficient way of delivering net gain by allowing efforts to enhance biodiversity to be focused in places where they will best be delivered, perhaps through bigger biodiversity schemes, but also allow the efficiency that can be achieved through a developer being able to pay money over to avoid having to look for bespoke arrangements either on-site or off-site for any particular development. And credits may be particularly useful for smaller developments which can't accommodate on-site works, or perhaps for those developments where, because of the nature of what's proposed, it won't sit comfortably with what is available on site. But also might be particularly useful in areas of high land values where local offsetting schemes may be particularly expensive to deliver. And I'm sure many on this webinar have experienced cases where finding the right translocation site or biodiversity offsetting site is more challenging than finding the land to develop in the first place, particularly in areas where there is a known need for this type of receptor site and so on. So just then, as to the other relevant provisions, the section, the Schedule 7A, which will be introduced into the Town and Country Planning Act, contains various regulation making powers. And that includes, I won't go through all of them, but it does include regulations which can be made to modify the requirements for biodiversity gain so far as it relates to irreplaceable habitats. Now, those will be defined in the regulations as made, but ancient woodland is the example which is most regularly given of an irreplaceable habitat, and one would assume that that would be brought within the definition. Regulations may also modify the requirements for particular types of planning permissions, including retrospective permissions, and that will be an area of particular interest, I think, because the Secretary of State is likely to exercise those powers to define the scope of these provisions. And whilst there are some exceptions on the face of the new schedule, for example, in respect of permitted development rights and urgent Crown development, on its face, the requirement for the biodiversity gain condition applies to all planning permissions. So one can immediately think there's going to be cases where, for example, for very minor development, where it would be surprising if there was a requirement to deliver biodiversity gain, but it may be that is what ultimately will be secured, and we have to wait and see the detail of those regulations. And I've touched on already some of the consequential amendments that will be made to the provisions of the Town and Country Planning Act. For example, amendments to section 73 to prevent the amendment of a condition, biodiversity net gain condition, through section 73, the same for section 96A, and also restrictions on the ability to modify planning obligations under section 106A for where they are concerned with the delivery of biodiversity net gain in accordance with the provisions of Schedule 7A. So a fairly broad range of changes to the Principal Act, which will, as I say, in my view, have the effect of entrenching these provisions in the Town and Country Planning Act, in permissions granted under the Town and Country Planning Act. Once those conditions are applied, as they must be under Schedule 7A, it will be very difficult to get around them. I wanted to touch on biodiversity net gain in infrastructure because, as I've already explained, the proposed provisions in the bill relate to the Town and Country Planning Act and not to the Planning Act 2008. For schemes, nationally significant infrastructure projects under the 2008 Act, there isn't a generalised support for biodiversity net gain in policy. As some people will be aware, one of the issues with policies in the suite of national policy statements is many of them are very old, But biodiversity net gain is mentioned obliquely in various places, for example, in the slightly more recent National Networks National Policy Statement. There was an interesting decision last week, I think it was, for Cleve Hill, the first onshore, first solar scheme permitted under the 2008 Act, a very large solar scheme in Kent. There, the Secretary of State approved compulsory acquisition powers for a plot of land which was only in to deliver biodiversity net gain. And the examining authority had cast doubt on the necessity for compulsory acquisition to achieve biodiversity net gain. And the Secretary of State disagreed and found that there was a compelling case for acquiring land to deliver biodiversity net gain, which I think is a good indication of the way in which it's being viewed in government, a benefit of the scheme, but something really which is regarded as quite central to the scheme as well, the provision of biodiversity net gain there in the context of the energy scheme. So then what next? Well, I think obviously the first consideration is the progress of the bill, and I think as David has already explained, we expect that to start moving again sooner rather than later. The detail, I think, will then follow. The establishment of the biodiversity credit system is going to be of particular interest because presumably for many developers, the primary question is going to be how much is this going to cost? And the biodiversity credit system will give at least a baseline, because if it's possible to pay out money under the biodiversity credit system, then any on-site provision or off-site provision is really just going to be looking for a cheaper solution than the biodiversity credit system and the use of the idea of banking. I think there are issues about local plan policies, and particularly where local plan policies have sought to set a threshold of biodiversity net gain, and obviously they're going to be overtaken by the statutory requirement to impose a particular condition. But there may be debates about how then any further biodiversity gain policies in the plan are given effect, given the presence of the mandatory condition. And then I think in terms of the scale of the impact, a lot will depend on what is taken out by regulations from the scheme of the Act, and which permissions are carved out, if any, and which permissions are within the requirement for the mandatory condition. So overall, standing back, I think a pretty powerful set of amendments, very controversial, as David has hinted at. There are clearly concerns in the development industry about the scope, and some of those points will need to be explored further. I think there are going to be issues about whether this scheme, this statutory scheme, achieves an overall improvement in biodiversity. The worry, I think, for some is that a credit system can be used to deliver cheap biodiversity elsewhere at the expense of a loss of biodiversity on sensitive sites, perhaps where the local nature network is more under pressure. Effectively paying money over to deliver enhancements outside of those areas where housing is in demand. So those sorts of issues are going to be quite difficult to work through, and clearly the need to still consider the current potential of the site and the proposed potential of the site in terms of biodiversity will still be central. So we'll still have to go through that basic process, whether under the EIA regulations or just as a matter of standard ecological assessment, to reach conclusions about the acceptability of the scheme in planning terms. So a lot still to think through, and much controversy no doubt to come. I'll hand over now to David.
Thank you, Richard. Thank you. I think we've got loads of questions, and thank you for those. A lot of them are quite tricky and are ones that lots of people are asking at the moment, and I will field those as best we can. And as I've said, any we can't deal with now, we will seek to provide an answer by email in due course. I'm going to take the first question just to get the ball rolling, which is the question about to what extent can the biodiversity gain requirements be imposed on existing permissions or on subsequent stages in the planning process. The implied condition that Richard's just mentioned, which is paragraph 13 of the new Schedule 7A, says that it's a matter for imposition on each planning permission granted for the development of land. Planning permission isn't defined except that it's said to include deemed permissions. And the question arises is, does it have the normal narrow meaning, which is well entrenched in planning law, which is to say it is actually the grant of planning permission and not subsequent applications, reserved matters, approvals under conditions? Or does it have an extended meaning, as the Court of Appeal recently held in the Fulford case for the purposes of Section 96A, so that you could have a non-material variation to any form of condition, whether imposed at a subsequent stage or at the planning stage? I think the better view at the moment is that planning permission means what it says. It comes in via Section 90A, which is of a piece, in a sense, with the imposed condition for the implementation of planning permissions, that is the time condition, which is the other main imposed condition. And it's interesting, the government's response to consultation in this time last year said that there was a debate over whether it should be applied to reserved matters, but that there was no consensus. The explanatory memoranda, the explanatory notes to the bill don't say anything other than repeating the words grant of planning permission, which suggests orthodoxy. There's no suggestion it should have an extended provision, but equally there's nothing in the bill which actually rules it out. But as I say, I think the orthodox approach would be to say planning permission means literally the grant of planning permission. There are, of course, additional difficulties. What if the grant of permission predates the coming into force of the bill? These provisions are on a date to be appointed by regulations. There may be transitional provisions that are relevant, but you would then have the possibility that if some authority seeks to impose this on a reserved matters approval, say for landscaping or ecology, you might have an argument that you're seeking to undermine or derogate from the original grant of permission, or that you're modifying it without compensation. There are provisions for regulations to be made, as Richard has mentioned, but they don't specifically deal with the definition of planning permission. Richard, do you have anything to add to that?
No, I think, just one point actually, perhaps Section 73, of course, is going to be a big issue. I think one of the questions in the question and answers touches on this. Obviously, Section 73 creates a new permission. So if a permission is issued under Section 73, on its face, unless separate provision is made, and it may be in regulations, it will be subject to the mandatory condition. So that's going to be a particular issue for large-scale developments.
Yes, because the amendment to Section 73 you mentioned earlier excludes the ability to modify the statutory condition. You can't remove the statutory condition on Section 73, but of course it will be subsequent to the coming into force of the Act, and therefore one would have thought that paragraph 13 would apply to it as the new grant of permission. Precisely. Right. I think that's enough of that particular issue. Matthew, there are a number of points arising with regard to recovery strategies. Can you deal, please, with the question of the overlaps between the various authority objectives? Natural England and the various other authorities have all got different responsibilities with regard to such matters.
Absolutely, David. It's a very good question. I think that the first point to make in relation to that is that the strategy is to be produced and published by whoever is designated by the Secretary of State as the responsible authority. And so it's an appointment by the Secretary of State. It's led by the Secretary of State in any given instance. And so the Secretary of State can appoint one authority to be the responsible authority. There's no provision for sharing the responsibility between multiple different agencies. So it could be a local authority for a particular area. It could be Natural England. It could be a national park authority. And in terms of dealing with overlaps, there obviously are going to be significant amounts of overlap in terms of expertise, resources. I think all of this is going to be resolved in regulations because there's just simply not enough in the primary bill at this stage, and the regulations suggest that there will be some provision for what sorts of responsibilities are going to be on authorities who aren't the responsible authority to provide various information to whichever authority is responsible, and a reciprocal obligation placed on whoever the responsible authority is to make sure that they consult with other relevant stakeholders in the area to make sure that all of those overlapping issues are dealt with.
Thank you. If we have a moment, I'll come back to some more of the questions in relation to those. But can I turn to Stephen now? There are a number of questions about conservation covenants. Stephen, what about the issue of whether a private body can be a party to one of the agreements?
Yes, good question. I think underlying this question is, can a private company be a responsible body within the meaning of the Act? Obviously, the landowner very often is going to be private. But in terms of responsible bodies, on the bill as it's currently drafted, yes, a private company can be a responsible body. Again, as currently drafted, some of its main activities have got to relate to conservation. So it's not carte blanche for all private companies to be responsible bodies. And secondly, if they want to be designated, like any applicant to be a responsible body, they have to be quote unquote suitable. As to what that means, the bill affords the Secretary of State power to draw criteria as to what is meant by suitable, and if he or she does so, then those criteria have to be published. So as things stand, in a nutshell, there's no bar on a private company being a responsible body. I'd also add this, that there's also a provision in the bill for the responsible body that's a party to the agreement to appoint another responsible body as its replacement. I mean, this is subject to various technical provisions, and provided the agreement doesn't preclude this. But what this means, it seems to me, is that there might be companies out there, and some of their representatives might be listening or watching. They might be very interested in being responsible bodies, or if you like, within the pool of responsible bodies. And then in any individual case, for any individual parcel of land, the two parties to the agreement might elect to appoint this particular company from the pool. So there is scope there for the marketplace, I think, to encourage private companies to get themselves designated.
Next, biodiversity gain again. I'm trying to take these more or less in order so we can vary the subject matter a little. But so far as net gain is concerned, Richard, we've been asked the question, well, what about enforcement?
Well, enforcement is enforcement under a condition. So same series of enforcement powers: breach condition notice, enforcement notice, injunction. All of those will be available for breaches. The provisions contemplate that biodiversity net gain may also be secured, particularly for off-site provision, through a planning obligation, and then of course you'd be in the normal enforcement mechanism for planning obligations.
What about the issue of you get to the point where you apply whatever the final version of the metric is, and we're at a late beta test version, aren't we, on the DEFRA testing? What if that renders a planning application for a development unviable? Does that allow a get out for imposing the condition?
Yes, in terms of the metric, we have got an advanced version of it, and it's the metric produced and published by the Secretary of State. But on the question of viability, there's no express provision for viability exceptions. So again, that could be dealt with by regulations, because the regulation making power is a broad one. Any application, any permission could be excluded from the provision by regulation. But I'm not aware of that having been proposed by the government to date.
Thank you. In terms of local nature recovery strategies, Matthew, how do you see that working in practice with particular local conditions? We've got some questions, for example, who's going to undertake the work if you've got overlapping requirements and overlapping sites? And what do landowners do about that?
Yeah, I mean, there's been a series of questions that have come in about this, and I think they're all, again, very valid questions. The first one seems to be about local habitat maps. How will they be produced, and will there be an opportunity for landowners to make representations? And again, the trouble is that we're still waiting on a lot of this detail to come by way of regulations. We know that the process in relation to mapping will be led by the Secretary of State, who will, in the first instance, publish a national habitat map, and it will then be down to the responsible authority to prepare the local habitat map. There's nothing specific at the moment about landowner consultation. However, the statute says that regulations may make provision for consultation of members of the public. So I would suspect that it's likely that the regulations will make provision in that way. So landowners would have an opportunity to get involved in that way. There's then a linked question of, well, once a strategy has defined some land as being, for example, land which could become of particular importance for biodiversity, is there any scope for a landowner to challenge this? And I think I can think of three ways in which that. The first is by way of the periodic review process. So every strategy has to periodically be reviewed. So there'd be scope for a landowner challenging a particular designation the next time that particular strategy has to be reviewed. The second way could come about by way of a dispute resolution process provided for in regulations. The regulations don't have to provide such a process, but it seems to me that there's clearly there's an extent to which that the statute is envisaging a dispute resolution process being brought about by way of regulations. So we could see a landowner responsible authority public inquiry, for example, as that sort of process being instituted in regulations. And then I think the third potential challenge, which really would be a last resort, would be if you're unhappy with the publication of a strategy and you don't want to wait 3 or 5 years, depending on how long it's going to be before the thing gets reviewed, you could bring an application for judicial review. So they're the three ways in which there might be a role for landowners to get involved. And then finally, there's again a linked question about what weight would a strategy designation have in the planning system? And I think that's a really good question. It seems to me that if a strategy is to have any teeth whatsoever, there needs to be a particular weighting that's required as a matter of national policy to strategy designations. As to what that weighting will be, we don't know. I suspect it would need an update to the NPPF to reflect the fact that these strategies have come into existence. That's probably how I would anticipate it happening. In the meantime, whether it could be the subject of national guidance, I don't know, but that's still to be seen.
Thank you. Before I turn to another question on conservation covenants, because I think we've got time just for a couple of additional questions per person. Can I just deal with some general questions? So far as the bill's concerned, the bill process, as we've said, is stalled. It's at public bill stage. It's already had, I think, 5 or 6 days worth of hearings. They're working their way through clause by clause. I mean, it's certainly possible that the bill will receive royal assent before the summer. I mean, it's certainly a flagship bill, and it's part of the Brexit commitment to get the bill in place, particularly with a number of the regulatory provisions. As to whether this can be taken into account by planning authorities at this stage, the answer is probably not, because the proposals are proposals which change the law, and until the law is changed, it's unwise to preempt. The issue on however, the draft metric, which, as I say, is at a beta stage, although consultations on that closed earlier this year, may be relevant where you've got policies already in local plans for biodiversity net gain and the like. And so there may be aspects of the emerging policy which are relevant, but it would be unwise to place too much weight, if indeed much at all, on emerging provisions until they've reached final form. If you want to see the amendments to the bill, by the way, there's a very good bill website on the Parliament site. It's got a consolidated list of amendments to date, and they, of course, are still to be voted on. And you can see just how far it's got. And as Richard said, there's a track change version of the bill which shows you the differences between the bill as it was introduced originally before the election and the bill as it was reintroduced on the 30th of January. Stephen, can we come back now briefly to conservation covenants and the overlap or the possibility of using such covenants to deal with matters already dealt with as mitigation, such as SANGs and the like, and whether or not those covenants may also, and this is in the context of SANGs and generally, include public access requirements.
Yes, well, I'll deal with the second point first. There's no obligation to make provision for public access in the Conservation Covenant Agreement, so it's an option rather than obligation. That may come as some relief to landowners or landowner representatives who are watching and listening, I do not know. But anyway, no obligation to include public access. So far as the first question is concerned, I think the question really is, do these conservation covenant agreements have to be linked to the planning system in some way, or can they be, if you like, entirely freestanding agreements? And the answer is the latter. They can be entirely freestanding. And I mean, I have seen and read reaction to the proposals on the part of landowners who are greatly looking forward to the, what they hope, imminent day on which they can enter into an agreement so as to preserve a particular or conserve a particular part of their land. In the case of freehold owners, as I said before, until the end of time. So they are looking at parcels of their land they particularly cherish, that they want future generations to cherish, and unless and until the agreements are modified or discharged, they will, as I say, these obligations continue for all time, whether they're positive obligations to do something or negative obligations not to do something. So the answer is no, they do not have to be tied to the planning system and planning applications at all.
Can just on that latter point, and the permanence of conservation covenants and the time limitation of biodiversity requirements, if you look at the amendments proposed to the bill, one of the amendments, I think, proposes to make the biodiversity requirements perpetual as well, to mirror the conservation covenants, but who knows whether that will get through in due course. Richard, can I ask you one final question about biodiversity net gain, which is, can local authorities improve, if that's the word, on the 10% metric? In other words, can local plan or neighbourhood policies require more than the 10%?
Well, as a matter of policy, if it can be justified, shown to be sound, there's no reason why they couldn't adopt a policy which required a higher level of biodiversity gain for a particular development. The mandatory condition would still have to be imposed, but they could, as a matter of policy, also require a higher threshold for a particular site or across an area of within their area or the whole of their area, as a matter of policy. And that's why I think there is an issue about some local plan policies that I can think of without mentioning any in detail, which apply to specific strategic sites and impose a net gain requirement as it stands. And there may be issues about how you give effect to that policy whilst also applying the mandatory condition.
Thank you. I think it's 3:15 and probably proper time to draw stumps at this point. As I've said, we will look through all the questions, and thank you very much for your participation and the interesting questions we've been asked. Of course, time dictates that we can't answer all of them at the moment, but we'll try and come up with some written answers which will be circulated in due course. We will put a recording of the seminar and also make available copies of the slides on the internet, and there'll be a circular going round from our marketing team with regard to that. Other than that, can I put in a small plug for Matthew Fraser, any member of UKLA? He's standing for the council and is very keen to serve. Other than that, can I thank Stephen, Richard and Matthew for their participation, and can I thank you all for attending? Thank you.